What are some possibilities as far as elder care planning is concerned? Attorney Christopher Hayner explains. A knowledgeable estate planning attorney should also be very well versed in elder care planning. The two practice areas are closely related. An effective estate plan can quickly amount to a hill of beans if an effective elder care plan is not also considered. Estate planning is primarily concerned with wealth planning during life and asset transfer after death. Elder care planning aims to preserve assets by structuring assets in such a way that a client can qualify for available government benefits if the need arises for long-term care. As part of our holistic approach, we not only discuss a client's assets, but discuss possibilities of structuring and planning for these assets to ensure both an effective estate plan and to maximize a client's ability to qualify for government benefits, namely Medicaid. Depending upon a particular client's situation, it may be advisable to create and fund a Medicaid Asset Protection Trust. Assets that are deposited into a Medicaid Asset Protection Trust will be Medicaid protected if the client does not require a long-term care prior to the passage of 5 years. Such Medicaid Asset Protection Trusts also have numerous other advantages, which I'm happy to discuss with any potential client. Because each client is an individual, any elder care plan and estate plan must be customized to suit the client's needs and desires. For example, an attorney should always take the time to figure out who the client is. Is the client healthy? Who are their loved ones? Would they rather spend their assets on long-term care instead of preserving an inheritance for their family and loved ones? The other major component in elder care planning is creating advanced planning directives, which include a power of attorney, healthcare proxy, and living will. These documents are intended to ensure that if a client ever loses capacity, he or she has a stand-in of who can make decisions for the client. A power of attorney is a document by which the client, in this case referred to as the principal, designates a family member, loved one, or trusted advisor, called an agent, to make financial decisions for the principal. While a power of attorney should be custom drafted to meet a particular client's needs and desires, a typical power of attorney will give the agent the authority and ability to access and manipulate the principal's assets so that these assets can be preserved for the principal's future use or can be saved as an inheritance for those people named in the principal's last will and testament. The importance of having a power of attorney cannot be overstated. In practice, the power of attorney is typically employed when the principal loses capacity, and the need to pay the principal's bills or engage in elder care planning for the principal is advisable. A healthcare proxy is similar to a power of attorney, but the healthcare proxy is used to appoint an agent to make healthcare decisions for the principal if the principal loses capacity. In the absence of an appointed healthcare proxy or agent, New York State surrogacy laws will control, which may lead to undesired results. A living will is a document addressed to a client's healthcare proxy or agent that details a client's decisions as to whether to receive care if the client is in an irreversible coma. Call now for a personalized evaluation or visit his website at www.chaynerlaw.com.